They're not your friends. They're students. You're the teacher. So act accordingly. In case you didn't get the memo, we can't use corporal punishment any longer in Illinois. All right? So if you had plans on, now back in the day, back when we tamed the prairie, okay, those sorts of things were permitted. But corporal punishment is not allowed, has not been allowed since the 80s in Illinois. Okay? Now, if you go south in some parts of the old Confederacy, they still believe in spare the rod, spoil the child, but that's not the way it is in Illinois. Okay? Teachers are employed to teach the curriculum prescribed by the Board of Education, and then that goes hand in hand with 16. A teacher who expresses opinions in class can be dismissed. You're saying, are you kidding me? That's true? That is true. And from no less a source than our own Seventh Circuit Court of Appeals. Now, the Seventh Circuit Court of Appeals is our federal appellate court that governs the states of Illinois, Indiana, and Wisconsin. It's one step below the U.S. Supreme Court. They recently had a case, the Mayer case. Now, this is out of Indiana. Mayer versus Monroe County Schools. This was a non-tenured teacher who, when asked by a pupil about whether she participated in political demonstrations, she responded by saying that when she passed a demonstration against this nation's military operations in Iraq and saw a placard saying "Honk for Peace," she honked her car's horn to show support for the demonstrators. She said she honked for peace. At the end of the school year, she was non-renewed. And she contended, and just similar to Illinois, Indiana has a policy, they didn't need to provide a reason. But as a matter of constitutional law, you can't dismiss somebody for a constitutionally impermissible reason. And so she contended, they dismissed me for a constitutionally impermissible reason because I expressed my opinion about the war in Iraq. Now, after this, she had said this, the memo came out from the principal saying, look, we don't want any more comments about your personal views on Iraq. This went to the whole faculty. And, but we could teach both sides, but not specific opinion, your own opinion. And she complied with that. But she was still dismissed at the end of the year. So she brought a lawsuit saying, they dismissed me because I expressed this opinion. The Seventh Circuit Court of Appeals said, that's okay. That the district had the right to do that. Here's what they said. Seventh Circuit, and this is 2007, a relatively recent case. Teachers are paid to teach the curriculum as prescribed by their superiors. This termination was legal since she wasn't being paid to provide her opinions. She had been directed to teach about the war and provide opposing views. Teachers are not permitted to use classrooms to promote their views contrary to the prescribed curriculum. Now, here's what they went on to say. They went on to say, and many people found this disturbing, because I know that when I asked this in my school law classes, where I'm teaching teachers who want to become principals or principals who want to become superintendents, anybody ever expressed an opinion in a class? Everybody's like, well, yeah, I know I did when I taught. Now, the key part here is she's non-tenured. Okay, had she been a tenured teacher, this would have been a different story. She would have been required. They would have been required to determine whether this was remediable or irremediable behavior. It certainly would be remediable. A note would have gone into her file and said, "Hey, don't do this anymore. Hey, we don't want to be in Indiana. We don't want you talking anything about peace. All right, peace is off the record. We don't want anybody talking about peace. All right, bombing people, fine. All right, war, yes, but not peace. Just a joke, folks. All right. I'm sure there are a lot of good people in Indiana. All right, but what they but that's one of the key points here. And what they also said was critical is that if they had to decide between a board making decisions about curriculum, which is a duly elected body, or leaving it up to individual teachers to decide what curriculum was going to be taught, they said we don't have any choice. We have to go with the duly elected Board of Education. So everybody, this case kind of caught some people and caused everybody to kind of take a step back, but I think the legal analysis is correct. The board is the one that sets the curriculum. Now, certainly the way it operates, teachers have a lot of say-so about what gets taught. In fact, if I'm your principal, I'm relying on you because many of you have expertise in areas that I don't have. I'm going to be expecting you to help me put together a curriculum. But the key point here, especially for non-tenured teachers, is you want to stick to the curriculum. Okay? What else do we have here? Okay. Yeah, we can provide alternative assignments to accommodate students' religious beliefs. Now that goes up to only to a certain point, though. For example, what if you had a parent that came in and said, well, I don't want my kids to learn about fractions. We're a decimal family, all right? We go strictly with decimals, okay? Well, schools have the right to dictate what the curriculum is, okay? And so we generally will provide accommodations for kids. You know, for example, the Mennonite kids that are a little bit more modest in their clothing, or you know, students whose parents don't want them to, you know, learn about where babies come from the school. We'll give certain accommodations for religious, and that's perfectly okay. But I also want to emphasize the point that schools, in some cases, have said, no, this is our curriculum, and we will not provide an accommodation. One was an example out of Massachusetts recently where parents wanted their kids out of to learn about different kinds of families. Well, civil unions are legal in Massachusetts, and the school said, look, this is the real world. We're going to teach about alternative types of families, and so we're not making an exception. The parents took them to court, and the Massachusetts Supreme Court said, hey, the school is the one that prescribes the curriculum. All right. All right. Teachers cannot be required to dispense medication, but they can volunteer to do so. In Illinois, a teacher cannot be required to dispense medication. Right there in the code. But you can volunteer. And as a tenured, non-tenured person, you might be willing to volunteer. But here's the thing I would say, because every community has its own norms. I would not dispense medication. I would beg, I would plead, I would say, you know, I feel very uncomfortable doing this. I would want to talk to somebody. If you were put in a position where they're saying you're going to dispense medication, because you really expose yourself to some liability if something should go wrong in those circumstances. Now, most of the time they're going to give it to the school secretary. So there's a special place in the afterlife for those folks, right? They do it all. But you cannot be required legally. The legal answer is you cannot be required to dispense medication in Illinois as a teacher. Can't. Yes. The statute does not make any exceptions for field trips. Well, I'll tell you what happens is that the principal comes to you and says, you know, gosh, Jimmy's got to go on the field trip, and he can't go unless he's got his medication. Now, generally, he would come down based on our school policy. He would come down and see the nurse, and the nurse then would dispense this medication to him on a regular basis. But we can't send the nurse, so would you do it for us? And because if you don't, then Jimmy can't go. Now, I'll tell you what, the legal answer is very simple. Sir, this Illinois school code says I cannot be required to dispense medication. But if you're talking to your principal and you're a non-tenured teacher, you might want to consider a different answer. And yeah, Dr. Bates?
So if you do volunteer, and something does happen, will the school district leave you off to dry because you did something wrong but you didn't have the training, or how would that situation kind of unfold?
Everybody's going to get sued. That's the first rule of litigation, of course. Now, the thing is that everybody's going to get sued. Yeah, and if let's say if the nurse is giving you the wrong dosage, or the principal gave you the wrong dosage, then you're on the hook. Now, if the nurse does it, that's not your problem. But here's what I would say, is that if push came to shove and you really had no choice as a non-tenured teacher, I would want to insist on something in writing, outlining what, from the nurse, from the parents, from the kid's physician, and they should have all of this on file. If a kid is taking medication in your district, they should have all that information on file already.